let me start with time. And time is important because after the 2013 presidential petition, the most we heard about when people questioned the judgment of the court, they questioned its depth, saying that it was a very shallow decision, that it didn't create any good jurisprudence, which Wachira has discussed. In fact, extremely retrogressive jurisprudence, and a number of us have written extensively on this. What we constantly heard from the court is, what can you do in 14 days? That was a standard response. And as late as, I think, May or June this year, when I went to a forum to discuss the draft rules, presidential rules for the Supreme Court 2017, one of the judges from the Supreme Court who attended, that is one of the things he kept emphasizing. It's not enough time. We know there were even attempts by the judiciary to lobby Parliament to increase time to 30 days. I do agree, 14 days for a presidential election, and now that it's getting more and more complex, especially with the technology, may not necessarily be sufficient time. But I also think it's important to put this into context. The context is this. One, on issues purely of law, the ones that Wachira discussed, the court knows ahead of time, in fact, years before, that those issues will be coming before it. So judges can get prepared on certain things, like do they want to revisit what they found in the past, and especially some of the issues discussed here on the law. So what is largely left in terms of what the judges cannot probably plan for in advance is the issue of evidence, the kind of evidence that will be brought. But I also want to put this in another context. On August 7th, 2017, right? The elections were 8th, right? On August 7th, 2017, AFRICOG brought a petition. The petition had been brought the Friday before, so 7th was Monday. That petition was heard before Justice Odunga from 10:30 in the morning. That petition was talking about the 400 meters, about disclosure of information, about the shutdown of or threats to shut down the media, among many other issues. Justice Odunga had advocates until about 12:30, 12:45 that day. At 4 p.m., he had a fully reasoned judgment. That's one judge, one day. We have 7 judges, and I will be explaining how the time has changed this time around. We saw that again at the High Court with the question of procurement of ballots, how long that took, and the judgment that was rendered, and very lengthy reasons, including at the Court of Appeal. So I think as much as the Supreme Court says it doesn't have time, and we're not saying that maybe 14 days, or I'm not saying that 14 days is very, very generous time, I'm not sure that now that has not become an excuse that the court uses so that it sometimes can be able to legitimize why it's not able to lend a very coherent judgment. So what has changed in terms of time? So we all know 7 days to file the petition. The 7 days don't count when you're computing the 14 days. So it's 7 days, and then the 14 days starts running from the 7th day. The petitioners are given 2 days to serve, and they can serve either by presenting the documents to the respondent, or they can serve through newspaper advertisement. In fact, what we've seen with this petition, the 2017 petition, is they've done both. They served the parties, but yesterday, I think, and I thought I saw that they carried an advertisement in the paper. So that is sufficient. After service, the respondents are given 4 days to file their responses. So we are already in the 6th day of the 14 days, because remember, 14 days starts running from the day that the petitioners file their petition. Then after that, we go to pre-trial. Before I go to pre-trial, or the day of the pre-trial, there is an expectation that sometimes a petition can be filed the first day after the declaration. But we don't know how many petitions will be filed by the 7th day, right? Because it's possible to have multiple petitions. What do the rules say about that? The rules just say that this 14 days starts running from the day the last petition was filed. So for example, if there had been a petition that was filed, or if Raila Odinga's petition had been filed on Thursday, we would not have started counting the days from Friday, but from Thursday, unless another petition was filed on Thursday. The 8th day now has been assigned for the day of pre-trial conference, and then after the pre-trial conference, the rule says that the hearing starts immediately and proceeds without any interruption until the court is done with the hearing. How has that changed from 2013? Quite a bit. In 2013, the pre-trial was the 9th day. But beyond the pre-trial, the court gave 2 days after the pre-trial for interlocutory applications or the interim applications before it started hearing the petition. So that by the time the court was starting to hear the petition, it was on the 11th day. So reducing its time to hear the petition, the substantive petition, quite drastically. Now, the court starts on the 9th day, but we can even argue the 8th day. And this is important. Why is it important? Because when is the 8th day? It's Saturday, right? Why is Saturday important? Because of our Chief Justice, right? Remember? So on Saturday, we'll have a pre-trial conference. There's no requirement that pre-trial conference has to have all the judges. But given the nature of this petition, it's not unlikely that we'll have it's possible that we'll have all the judges. But when the rule says immediately, they don't mean, in my view, that you start on the 9th day, which is the Sunday. It means that if the pre-trial is finished by 10 o'clock on Saturday, there is nothing to stop the court from hearing the petition from 11 o'clock on Saturday. I don't know how the court will work that out, especially in light of our Chief Justice during his interview saying there is nothing that can make him sit on a Saturday. I think everybody will remember that. So the other critical aspect of time that people need to know is that in 2013, the rule said that the court can render its decision on the 14th day or whenever before the 14th day, but could keep or could hold back on the reasons and the judgment, the writer part to explain the judgment, and the rules didn't give how much time the court had to issue the reasons. I think in 2013, and I might be mistaken, after they rendered the decision, they said they will be coming back in 30 days to render or to give the reasons for the judgment or for the decision. This time the rules are very clear. If the court decides not to give reasons by the 14th day, it has 21 days to give reasons. What are the type of petitions? And this is the second issue. Presidential election petition is covered by Article 163(3)(a). Article 163 generally is the article that has the various jurisdictions of the Supreme Court. But Article 163(3)(a) talks about Article 140, and this is important. because Article 140 talks about a petition on the validity of president-elect, right? So one would argue that the jurisdiction of the Supreme Court is limited to matters only of president-elect, so that if there is no president-elect, you cannot bring a petition to the Supreme Court. I'll give an example. Gladwell, when she spoke earlier, she said that when they went to the High Court in 2013 to ask for certain disclosure from IBC, even before the finalization, they were told this is so intertwined with the presidential election, so this is a matter for the Supreme Court. So then we didn't have president-elect, and the question becomes, could the Supreme Court take jurisdiction? But the Supreme Court is the one that created this problem for itself by adding or expanding its jurisdiction. A lot of us know that in 2012, there is an advisory opinion that was brought before the Supreme Court. It's called the Gender Advisory Opinion, right? This is the 2/3, right? Where the court was to decide whether if parliament that gets elected in 2013 was not 2/3 gender compliant, whether that parliament was unconstitutional. What most of us didn't pay attention to is that there was a second question in that advisory opinion on the scope of the Supreme Court jurisdiction. And in answering that question, the Supreme Court said that its scope on presidential election is wider than what is in Article 140. So that now when you go to the rules, you find that the court has tried to expand that. And what is that expanded scope? It's on anything that questions or may have an impact on the validity or the conduct of presidential election. I'll give you an example. A lot of us now know about Maina Kiai's judgment, right? High Court, Court of Appeal, because it became one of the biggest thing at Bomas. The Maina Kiai case was started at the High Court. The question in Maina Kiai's case was who had the final say on presidential election. Was it Chebukati, right? Right? Was it Chebukati or was it the returning officers of the constituency? When the case came to the High Court, the IBC said this case does not belong here because this is talking about the validity or it has an impact on how the presidential election is conducted. So it belongs to the Supreme Court. They opposed it there, but they were not successful, and even at the Court of Appeal. Even though at the Court of Appeal, it seems that the Court of Appeal took jurisdiction, not because it didn't believe that the question could go to the Supreme Court, but because it thought the nature of the issues or the questions that were being raised in the petition could either be had at the Supreme Court or the High Court. So it was fine. So what has happened is the Supreme Court has widened its jurisdiction. And when you go to the rules, you see a reflection of this, although not a full capture of it. So that, for example, on the 8th or the 9th morning, a lot of us saw Raila Odinga come out to reject the results as they were streaming, right? If they had wanted to challenge that in court on the 9th morning, they could have gone to the Supreme Court and they could have been able to cite not just the rules, but the jurisprudence of the court in the past. But beyond that, then the rules talks about invalidating the election. It talks about also in the case of runoff, those are grounds that can be raised. But I spent a lot of time talking about these other issues other than just questioning the validity of who has been elected. Because I think going forward, a lot of our litigation will be at that. When IBC is doing its stuff, when a number starts coming before the polling stations close, or 1 minute after the polling station close, some of us, I think, might have to go to court then, because it's probably the only way to capture the problems and don't get into the problematic situation that Washira was describing, that given the law today, it becomes very difficult to invalidate a presidential election. Disclosure, and I'll be quite brief on this. The rules now expect that whoever files the petition files everything they want to rely on in that petition. This is as a result of what was discussed earlier by George about the 700-page affidavit. Was it exactly 900 or 901? It's as a result of that, because remember what they did in 2013 is not to allow additional evidence, although George has a very good theory about what they allowed and what they didn't, which is factual, by the way. Yeah? So what is required now is you file everything, and the court seems like, even though there is a rule that says one could ask to file additional evidence, you can even tell the rule itself is hesitant, and I don't think the court will be allowing people to file additional evidence once the case starts. Why is this important? Because in 2013, what was anticipated is upon filing the petition, IEBC had an obligation to file certain materials relating to the election. And even later on, the court could require IEBC to file more materials. So that's what the rule says. The rules this time have taken that obligation completely. And so there is no requirement for IEBC to file anything, express requirement, other than when they are responding, like respondent. In 2013, they were expected to file as respondent, but also additionally, they were required to file certain things. Why is that, again, important? Because it goes to a critical question that Washira raised. What is the obligation of IEBC in the context of Article 86? Remember, who has the obligation to make sure that the election meets those requirements? The verifiability, accuracy, simple, and all that. Under Article 86, it's IEBC. But now when you look at the jurisprudence from Raila Odinga in 2013, and now the rules, it seems that really we are really getting away from that, and it becomes only a burden of the petitioner. Then I'll talk about, by the way, I should say on the disclosure, and this is what really pains me this time round. So you tell a petitioner that they must file everything when they bring a petition, right? You tell the same petitioner that even if they show irregularities, and Washira covered this very well, but they don't show how those irregularities affected the results, they can't succeed. So if you have to succeed, it's really counting beans under the 2013 Raila Odinga judgment. If you're not able to show the numbers, it becomes a very difficult case. I'm not saying impossible, but very, very difficult. Think about it, and this is information in public purview. On Thursday, NASA still had not received over 5,000 Form 34As. When NASA goes to prosecute its case from Saturday or Sunday, they'll be told, show us how your numbers are different from what was declared. Who has the custody of the forms with the numbers? IEBC. So this becomes even an access to justice issue and a fair hearing issue. You are not basically able to present your case. And it also goes to the discussion that was had, the moral hazard. What is the incentive for IEBC to have made sure that all forms were in before they declared the results? In fact, they have an incentive not to, because if they keep away the evidence, you'll never be able to prove your case.